while back, I'm Kyle. I'm one of the, I'm the associate reporter of the Restatement of the Law of Liability Insurance. And shortly after a meeting a while back, Dan came up to me and said, "What about this idea of a first-party insurance restatement?" And I laughed and said, "You're kidding, right?" And he said, "No, think about it seriously. Think about it." And so I thought, I'll give it some serious thought. So what I want to do today, I'm going to keep my remarks brief as well. But what I want to do is talk a little bit about some things that I think a person might want to think about if they're imagining being a potential reporter on a restatement of the first-party insurance law. So I'm gonna revisit some big conceptual questions that Tom and I faced together with the help of some advisors at the very beginning of the restatement of the law of liability insurance. Then I'll do a quick and dirty review of what I think are some rules in the restatement of the law of liability insurance that seem to apply to first-party insurance in a sort of obvious way and therefore might not need to be restated again. And then third, I'll talk a little bit about a few insurance-specific types of issues that we did not address that would be obvious candidates for treatment under new restatement, some of which overlap with what Ken said. And then I'll conclude very briefly with a comment or just a question about this genre of restatement that a future reporter might want to think about. So the big conceptual question we first faced was sort of how to organize the field of insurance law. What is insurance law? That's not a question people ask themselves very often unless you're writing a treatise or a casebook or something, or maybe trying to explain to your students why to take your class. But and it's a lot of things, right? There's regulatory aspects of it, but the parts of insurance law that are well fitted for restatement are basically contract law rules. And some might even say that insurance law is really just contract law. It's just an straightforward application of contract principles to standard form in insurance contracts. But anybody who's read any insurance contracts at all knows that that's not true. In insurance context, those tools of contract interpretation and et cetera have their own valence. In addition, because standard form insurance contracts themselves have their own peculiar terms, as courts apply the doctrines of interpretation and the tools of interpretation to particular insurance contract terms, a kind of common law arises about those terms that you don't see in other areas. Just for one example, Ken mentioned the duty to defend. The duties to defend, the duty to settle, these arise out of courts' efforts to try to interpret and give meaning to and make sense of provisions in insurance contracts that give insurance companies the rights and obligation to defend and the discretion to settle cases. But it's a kind of independent jurisprudence that very much deserves restatement, in my own biased view, and we have tried to do that. I should say that knowing that insurance law is a coherent, and so my conclusion would be that insurance law is a distinct field. That's sort of the first test you have. The next question is how to organize it. So that was hard. Ken has alluded to how hard it is to sort of figure out what to put in and what to leave out. And Tom and I thought about it. We asked for advice. We tried crowdsourcing it with our advisors. They didn't really have a lot of advice on this particular question. They had lots of useful advice from which I learned a great deal about particular sections. But this overall how to organize thing was really hard. So we did what we did. We have a chapter 1 on insurance policy, on contract doctrines, interpretation, misrepresentation, waiver, estoppel. Chapter 2 is where we address defense duties, duty to settle, duty to cooperate. Chapter 3 is a section where we deal with a lot of doctrines that have arisen out of courts' effort to interpret particular provisions in insurance contracts, liability insurance contracts. And Chapter 4 has rules governing implied law terms, remedies, and bad faith. And so that's the structure we came up with. It's a way of organizing things. One thing I'll point out in terms of a cautionary note is there's an additional risk to attempting a restatement of insurance-specific rules that are, by necessity, based to a large extent on the specific language of particular insurance policies. There's the problem Ken mentioned, the problem of picking the right level of generality. The rule must be sufficiently general that it will apply to a class of contracts that are in wide use, but it cannot be so general that it is unclear how the rule would apply to particular policies in particular situations. That's not so easy to do. And then there's the where do you stop problem that Ken mentioned. If there are 1,000 rules, how many do you include? I don't think that's as big a problem as Ken thinks. I wouldn't call it the restatement of the principles of the law of liability insurance. I might say it's the restatement of some of the laws of liability insurance. And we didn't get a lot of complaints about that. We didn't get people saying, here are a list of the rules from Couch that you didn't restate. Get on those. Instead, we tended to get the opposite. Could you not restate that rule that you restated? Just drop that one out. But anyway, it's an issue. The bigger issue that worried me, and that actually Ken put me onto early on, which is because most of the insurance law rules that we're restating are default rules that can be altered by changes in the language of the policy, they have a risk of obsolescence. If the insurance industry changes the wording, the rule disappears. One can plan against this kind of obsolescence by trying to state rules that rely on contract terms that have been around for a long time or that are in wide use, because then if insurers are going to change the language there, it seems unlikely they might do it because they also lose the benefit of all the contract law that you're relying on to state the rule, and that creates uncertainty for them. But the possibility of obsolescence in this area is a problem. So which rules set forth in the restatement of the law of liability insurance could cross over and apply to first-party insurance context? I think it's pretty obvious. Chapter 1, pretty much all of it is the rules of contract law. I won't go through them all again. Chapter 2, probably not. Probably none of Chapter 2 and the duties to settle and duty to defend and all of that. I think that probably doesn't apply. Some of Chapter 3, concepts such as trigger and allocation and the number of occurrences are terms that arise in property policies. Maybe some of what we did here could translate. And also some of Chapter 4. Certainly the definition of bad faith. We saw as many first-party cases as we saw third-party cases when we were doing our reading for this. So a fair amount would carry over. What's left to be done then? Ken mentioned insurable interest. That would be a very interesting thing to explore. I would also mention the problem of concurrent causation. When you have an excluded cause and a non-excluded cause, what do you do? Do you use the efficient proximate cause doctrine or not? There are interesting issues there. And subrogation. We mentioned subrogation in one section, but largely leave it untouched. So I would think subrogation would be a rich area to explore. So I think there's stuff to work on. I defer to Ken on whether it's plausible that it could be done now or when it might be done, but I think there's enough there to do another restatement, a much shorter one. It won't take 25 years, whatever ours took. It will take less than that. And then one quick final thought on the genre of a restatement, because that's what you'd be working in, I think. I think once one of them's a restatement, the other one has to be called a restatement. I don't see how you'd go to principles on the next one. According to the ALI style book, restatements are to be clarifications or reformulations of existing law, and to that end, they tell the reporters to look at a number of factors. What is the majority rule? Like what do most courts do? What are the trends among the courts? What rule provides the greatest coherence? And then which rule is most desirable? And these are the things you're supposed to consider. So I have some quick thoughts on these things. I would say there's also an unstated limitation that's not in the rules that we felt anyway. There is a strong preference for verbal formulations of rules that judges and lawyers are familiar with, even if they are not clear. I don't know how else to say it. It's just true. And we bumped up against that a number of times and had to make adjustments because of it. In choosing between alternatives, this is the second point, and I'm closing in here. In choosing with the alternative rules on the grounds of relative desirability, it presents a very familiar and difficult question, especially for law professors. What is considered a valid or persuasive reason for concluding that one legal rule is more desirable than another? The ALI style book offers some ideas. They say you can look at social science evidence or empirical analyses. They don't say that's exclusive, but they offer those as possibilities. But you really are confronted with a question of what counts as an argument for what's a desirable choice of a rule, and how is a restatement author supposed to deal with that? And I'll conclude with a hypothetical. Imagine that there was a jurisdiction out there that adopted, I don't know if I should call it Omri's rule or Steve Morrison's rule for interpreting the plain meaning of insurance contracts. Let's say, I'm not saying any states has done it yet, but let's say the Supreme Court of some state adopted that rule and said, this is what you should take into account in deciding plain meaning, these surveys and this database. Let's say maybe two courts did it. Two high courts have done it, but only two high courts. And let's say you think it might be an interesting rule to adopt. On what basis would you adopt it? Like, how would you decide that this is a rule that we could adopt? It'd have to be on relative desirability because it's not a majority rule. What are the criteria for deciding desirability? You know, do you have to show that the adoption of such a rule does not radically increase premiums or reduce coverage? Appears not to have in that jurisdiction, but we don't have a lot of evidence on whether it does in other jurisdictions. These are difficult questions for a reporter to answer, and thankfully, they're almost no longer my problem.